by Dave Sly. We wanted
I just started the record.
Yeah, that's fine. We wanted to let you know that tonight's webinar will be recorded, so just be aware of that if you, when putting things in the chat or when putting your name in places. So this webinar is the last of our trio of webinars that we've been doing as part of celebrating the Clean Water Act's 50th anniversary, which takes place next month. And these webinars, the purpose of them is just to provide sort of some nuts and bolts for environmental advocacy. And so tonight's is on the all about administrative processes and holding the government accountable. So as we go throughout the presentation, please feel free to put any questions you have in the chat or in the Q&A, and Haley will be collecting those and we will be doing those at the end of the presentation. So, all right, let's get started. So here's our agenda. What is the APA? Why is it important? And how do we utilize it? So the APA is the Administrative Procedure Act. It is a federal law that governs the process by which federal agencies make decisions. This includes developing and issuing regulations, as well as issuing licenses and permits. It was enacted in 1946 over concerns for the need for greater government transparency over agency decision-making as a response to the rapid growth in government administrative agencies that occurred during particularly the FDR administration. So what's important also is that this act establishes standards for judicial review of agency action. So that is one of the ways that citizens and individuals can hold governments accountable for decision-making. So there's the APA at the federal level, and then each state has their own individual administrative process act. In Virginia, it's the VAPA, it's the Commonwealth's version. It applies to Virginia state government agencies. It's very similar to the federal version, and it outlines the steps that Virginia agencies must follow for decision-making, including creating and finalizing regulations, as well as issuing permits. One thing that's interesting about the Virginia Administrative Process Act is that it allows individuals to petition for a regulation or a change in a regulation, and then the agency must respond to that. So we're all coming from different levels of familiarity with government agencies. So you might be wondering, well, what exactly is an agency? So it's actually an extension of the executive branch of the government that has the power and generally, ideally, specialized knowledge to make, interpret, and enforce regulations. And importantly, agencies perform executive, legislative, and judicial functions, which makes them particularly unique entities. Something else that is important to mention is that because agencies ideally have this specialized knowledge, they're generally called upon by the executive or the legislature to exercise this specialized knowledge in decision-making. And because of this, in judicial decisions, agencies generally have deference from the court. So what are some examples?
Can I interject?
Yeah, totally.
That term deference, it's maybe we can expand on that slightly.
Yeah, so agency deference is when a federal court yields to the agency's interpretation of either a statute that Congress enacted that the agency is charged with the responsibility and authority to administer, or a regulation that the agency has crafted or created.
Let me put it in a simplistic term.
Sure.
If there are facts, if I have facts and the agency has facts, or I have science and they have science, usually a court is going to say, well, I don't know who's the best science, so I'm going to trust the agency. That's something that, you know, a lot of people have seen. Yeah. You think your facts are great, you think your scientific interpretation is great, but theirs is going to get a lot of leeway. Yeah, and that's because the court views the agency in that situation as the expert.
So some examples of federal agencies, the EPA, that's one that we hear a lot about in the environmental space. NASA is also one that is fairly visible in the public sphere. And then one that we're all very familiar with after 2+ years of COVID is the CDC, or the Centers for Disease Control and Prevention. Examples of agencies that we have in Virginia, DEQ, the Department of Environmental Quality, who we deal a lot with, the Department of Education, which if you went to public school in Virginia or your kids are in public school in Virginia, you might be familiar with them. And of course, again, because of the pandemic, the Virginia Department of Health. So also something important to mention with regards to Virginia agencies specifically is that in Virginia, we, under the Department of Environmental Quality, we have 3 citizen boards that also fall under the realm of the Virginia Administrative Process Act. It's the State Air Pollution Control Board, the State Water Control Board, and the Virginia Waste Management Board. So what that means is that all of the decisions that these boards make, they are also subject to the same oversight laws of the VAPA as the agency themselves. And Dave, did you have any other comments you wanted to say about that?
Well, one thing about the Water Control Board that people may have heard in the last year, and you've seen that they have had authority to make regulations, but also to issue permits. That's true for the Air Board and the Waste Board also. The legislature, the General Assembly in the last year, took away their authority to issue permits and gave that directly to the director of the DEQ. So you may have seen that news. That's a pretty big change in Virginia, because those what are called citizen boards have always been trusted to make some of those bigger decisions.
So you might be wondering, why should I care about agencies or administrative processes? Well, it's because agencies are a part of daily life. They're occasionally called the 4th branch of government because what they do impacts our lives every day. From this glass of water that I have, there's an agency that regulates the amount of pollutants that is allowed to go into my drinking water. There's an agency that regulates every part of the development of my phone, what products can be imported or exported. And so I like this quote. I felt that it summed it up quite well, is that there's hardly any function of modern government that does not involve in some way an administrative agency. And the reason for this is very simple. Agencies are the only government entities equipped to deal with the day-to-day minutia of governing. So in essence, Congress might decide that we need to regulate transportation companies, but they don't want to decide how much it's going to cost to ship a package from Chicago to New York, for example. That's something that a responsibility that they would delegate to the agency, because that's the more mundane day-to-day stuff. So you might also be wondering, wait, where do agencies receive their authority from? If they have so much influence in our everyday life and they carry out all these policies, how do they have the power to do this? They're not part of any official branch of government. Where does their authority come from? So there are 2 types of administrative agencies. You have legislative administrative agencies and executive administrative agencies, and their names are just have to do with how their authority was received. So for legislative administrative agencies, those are agencies where their authority was delegated by Congress, or in Virginia, the General Assembly. And for executive administrative agencies, those are agencies where their authority is grounded in either the federal or state constitution. That's not a big distinction that you need to remember. It's just important for knowing kind of the context and the background of where this agency authority comes from. So it can come either from the legislature or from the executive. So the legislature gives an agency authority by an enabling statute, meaning that they pass a law that says we are creating this agency for this particular purpose. And similarly, the executive, the president or the governor of Virginia, can create an agency by executive order. we've seen some examples of this. NEPA, the National Environmental Policy Act, enacted in 1970, was the enabling statute for the creation of the EPA. And in terms of executive orders, one that comes to mind is President Bush's executive order after September 11th that created the Department of Homeland Security. So it's important to note that no matter how the agency received its authority, whether it was from the legislature or from the executive, the APA and the VAPA apply, meaning that these agencies are subject to those laws. So they're subject to the laws in their decision-making, and the decision-making is we commonly use this term agency action. And so that includes any part of the agency's rule or regulation, any order that they put out, guidance, any license that they issue, or any permit that they issue as well as a failure to act when they have legal responsibility to do so. So some examples of agency action: rulemaking, which is writing regulations and passing regulations. So for example, the EPA is currently engaged in a rulemaking process to revise the definition of the Clean Water Act term waters of the United States. And another example of agency action is issuing permits. And some of you here might be familiar with the Mountain Valley Pipeline work that Wild Virginia is actively engaged in, and there are multiple agencies there that bear responsibility for issuing permits for that project, including the U.S. Fish and Wildlife Service, the U.S. Forest Service, and the U.S. Bureau of Land Management. So these are examples of things that the agencies must do in accordance with the steps outlined by the APA, and if it's a state agency, we're talking about the VAPA. So why do these acts matter? Like, again, why should we care? Well, because agencies create environmental policy. We talked about rulemaking a moment ago, and rulemaking is making regulations. So, for example, a legislature might say, well, we passed this law and we want to, protect the waters of the United States from pollution. But it's up to the agency to determine, well, what water bodies does that actually cover? And what are we talking about when we mean pollution? So because the agencies have this specialized knowledge, this expertise, they are tasked with coming up with laws, regulations that help implement the policies that the legislature or the executive come up with. Another reason we care about agencies and why they matter is that because the administrative processes that agencies go through when they are rulemaking, when they are issuing permits or licenses, they provide opportunities for public participation and oversight. One of the biggest ways this is done, and this is outlined in the APA and the VAPA, is by requiring notice and public comment during these processes. This is one of the big reasons for the enactment of the Federal Administrative Procedure Act was this idea of having some sort of oversight over agency action and what the agencies were doing and what decisions they were making. And as part of this, the public was invited to participate in this process. So agencies must give notice, it must be published, and there must be a meaningful opportunity for comment. And additionally, another opportunity for public participation and oversight in these processes is when an agency is not doing what it should be doing. And there's opportunities to challenge the agency through judicial review processes. And like I mentioned, agencies do not always do their job. It's a failure to act. So agency action, the inaction can also be considered an action. And that the agency is then subject to these laws, the APA, the VAPA, and they can be challenged by individuals under them for failing to do their job or to do their job correctly. So agencies do not always follow the rules. They don't always do their job well or properly. And this is something we saw recently in the Mountain Valley Pipeline case. There were a couple agencies, the Fish and Wildlife Service, that was supposed to do a particular analysis of harmful impacts on aquatic species in the rivers that were impacted by sediment from this project. And the court found that the agencies had not done their job. They had done an inadequate analysis, and that their analysis, that their actions were in violation of not only the Endangered Species Act, but also the APA. And Dave will talk more about the Mountain Valley Pipeline and how we've used the APA to hold the government accountable there in a few minutes. So how do we use the APA and the APA to hold governments accountable for the decisions that they're making? So one practical thing to do is to follow agency action. And here are a couple websites where you can find out what the government is doing. For federal agencies, you can follow the federalregister.gov. That is where notices get published for any federal action, any kind of rulemaking or permit issuing. For Virginia agencies, it's townhall.virginia.gov. It's a very comprehensive website where you can find out what are Virginia agencies doing, what are they doing, what kind of actions are they taking that are impacting the environment. You can see that, yeah.
I'm sorry.
Oh, go ahead.
An important thing about Town Hall is that you can go in there and you can set alerts.
Yeah.
You were probably just going to say that.
I was, but that's great. Thank you for reading my mind. I was like, I'm really excited that you had that as well. Like, you should do this.
So if I want to know everything that DEQ is doing, which I don't really, but I do follow, it will give me emails whenever they have an administrative action that is happening. And that can be really valuable because, you know, things can slip by very easily if you're not really paying attention.
Yes. So if you're interested in watching over your environment and doing so by engaging in the administrative process, one way you can do that is setting up alerts on Town Hall. Here's just some examples, again, of agencies that you could follow their action of, federal agencies that deal a lot with environmental issues or that directly deal with various environmental statutes, such as the Endangered Species Act or the National Environmental Policy Act, or Clean Water Act, Clean Air Act, the National Oil and Gas Act, but that also approve or issue permits that directly impact the environment and can have significant impacts on the environment. And here's a list of Virginia agencies that do the same thing, just at the state and local level. So you have the Department of Environmental Quality, the Department of Conservation and Resources, VDOT, Transportation, and the Virginia Marine Resources Commission as well. So another way that you can utilize the APA and the VAPA to hold the government accountable is by participating in the public notice and comment process. And here are the links, the web addresses for where you can often do that. For federal agencies, regulations.gov, if there's a rulemaking that you want to comment on. Additionally, if there's a particular permit or license, that would be on the particular agency's website docket. You can look for it there. Additionally, for Virginia, Town Hall, again, has opportunities for public notice and comment, and you can search through the forums to find opportunities for commenting. And one main reason why you want to comment, not just in the hopes of informing the agencies in their decisions, which is what they're asking for when they issue a notice of a project and they seek comment, but also it is critical that if you want to challenge an agency action later on in litigation, that you comment in order to assert your right to sue in order to show that you have what's called standing. Dave, did you have anything to add about commenting?
Well, the first thing I'll add is that we do have another webinar that you can go and look at.
Yes, we do.
Ah.
If you want any
Man.
help with commenting, learning about that process, or tips for how to write an effective comment or deliver an effective comment, we have a webinar for that. And here's the link to that webinar. That was our first of these Clean Water Act 50 trios. So, and finally, one way to utilize the APA and the VAPA is judicial review. So both acts provide for judicial review of agency actions where appropriate. But it's important to note that not every agency action is necessarily subject to judicial review. And what we mean by the phrase judicial review is going to court, bringing a case against an agency, challenging them on a decision that they have made because you or your membership organization have been harmed in some way. So like I was saying a moment ago, this is partly why commenting is so important, because you're already participating in that process and you're asserting your right to sue before the agency has even potentially made an error of judgment, or alleged potential error of judgment. So again, not every agency action is necessarily subject to judicial review. It depends on constitutional considerations, statutory, as well as other factors and the facts of the case. But interestingly, under the APA and the VAPA, some agency actions are subject to judicial review by the same administrative agency that makes the decision. And they have judges, they're called administrative law judges, who would hear the challenge first. That is the first level of judicial review. And FERC, the Federal Energy Regulatory Commission, is an example of an agency that has that process. So in this way, we mentioned earlier on that agencies have executive, legislative, and judicial functions. And so this is FERC having a quasi-judicial function where if a FERC decision is challenged, such as the issuance of a license, then the first level of review actually goes to an administrative law judge within FERC, and the FERC administrative law judge holds a hearing, which is in that sense kind of like going to court, except it's at FERC. And then if that is appealed, then you would actually enter the court system. But that's something that is unique to sort of this whole agency process. And fortunately, there's still an option for the court to review the decision that came out of this quasi-judicial proceeding. And now we're going to go to Dave Sly, who is going to talk about the Mountain Valley Pipeline and use this sort of as a case study for how Wild Virginia has used the APA to hold various agencies accountable for the decisions that they have made.
Thanks. And I see that we have quite a few questions, so I'm going to try not to be too long-winded here. Some of you, I know by seeing your names, have been involved in the pipeline fights for a long time, so you'll know more of this. Some may be less informed about it, but as Jackie said, there have been many administrative processes that Wild Virginia and some of you have been involved in through the last 8 years or so, including the Federal Energy Regulatory Commission, Forest Service, Fish and Wildlife, Corps of Engineers, and then the states of Virginia and West Virginia. Of course, we have focused on Virginia when it comes to state actions. But I wanted to just drop back and say that any of these processes, including the MVP or the pipeline fights, you know, Jackie and I are both attorneys, if you can't tell by the way we talk. But it's important to remember that there's a legal aspect to this, but there's also an aspect of, you know, bringing in the public on our part. The agencies will run through these formal processes, and frankly, a lot of times they would be happy if they went very quickly and smoothly and quietly. And sometimes a big function of groups like ours is to make them a forum for getting more of the word out to our fellow citizens and to the media and to lawmakers. So I think that's an important aspect of it, is that this is just a really good public forum that we can use beyond the strictly legal sense. Although we're always paying attention to that. And a lot of you who have worked with agencies, including those in Virginia, DEQ and the Water Board, will know that it can be very frustrating to try to make them listen to your points and respond to them. But I will tell you that from long experience with agencies through the years, that sometimes you can make novel suggestions. You can do things that aren't necessarily going to lead to some kind of court action that they can see makes sense for them. One of the things that happened early in the pipelines is that landowners started pointing out, I have a spring, I have a stream, I have a place here that you have not accounted for in your actions. And so some of that really firsthand information is really important. And again, even if an agency does not agree with your arguments about what should be done or why, bringing them very substantive information like that they just don't have can make a difference. So again, with the Mountain Valley Pipeline, we've been going through processes with all those different agencies on both the federal and state level, using that has involved the federal APA and the state APA. In each of those cases, what we're trying to do, because of the principle of judicial deference that Jackie talked about, is we're trying to show that certain proposals or certain actions that the agency might propose are just not paying attention to all the right facts, that there's a term called arbitrary and capricious, which that's a standard under which the court may say, no, this agency's action is not appropriate, it's not proper, they didn't meet the requirements. So when we go into these comments, we're looking, as I say, we can stack up our scientific arguments next to theirs, and often we will not be successful because the court will side with them. But what we've been able to do, we and again many others, is to show in some of these cases through the Mountain Valley Pipeline that the agencies just plain ignored facts, or they just refuse to consider certain factors that were key to the issues. One of the things that has been very effective for us, when an agency decides to issue a permit or proposes to issue a permit or regulation, they will release a certain, set of information. They'll have what they call a fact sheet or an agency background document that explains this is what we want to do and here's why we want to do it. Very often that's an incomplete kind of explanation of what's going on. And one of the things we've used pretty effectively is to go get our own information from the agency themselves. Again, we've had a webinar before about the Freedom of Information Act. And sometimes it's really necessary for you to go dig out information to feed into the system. One of the really valuable things I think has been that when you're using their own information that they hadn't injected into the process, that's pretty powerful. And so we've done that in a number of ways. On on the federal level, that was really important when we were challenging the Forest Service decisions on both MVP and the ACP. What we showed, we and others again who brought out information, was that the Forest Service experts, who again, they're supposed to get deference for a good reason, but their scientists, their engineers, their hydrologists were telling the pipeline companies, and they were telling FERC, no, you haven't done all the right studies. You have not proven that you can build these pipelines where you want to build them without causing great damage. And then somewhere along the line, the people in charge of the Forest Service in the administration just overrode what those scientists were telling them. We wouldn't have known that if people hadn't gone and done FOIA requests and gotten that information. And that's one of the things that the courts saw. They said, hold on a minute, there's a disconnect here between what your experts are saying and the decision you made. So that, that was a really important thing. Some of the other decisions that have been made that we've challenged in court and won, for example, with the Corps of Engineers, they proposed twice to cover the Mountain Valley Pipeline under what's called a nationwide permit. So essentially, it's a permit that covers every project in the country that is in the same category. And we said repeatedly, no, it doesn't fit under this category. That's not appropriate. It's not what the law intended. And so it was kind of a procedural argument, and the Corps eventually, well, they lost in court with the attempt to cover it under the nationwide 12. And finally, we ended up with the decision that no, it's going to be covered under an individual permit. So that wasn't so much an argument about the substance behind the decision. It was the process, the procedure for actually coming to a decision. And there's so much that I can talk about with the pipeline. And again, you who have followed along for all these years know that many of us have filed thousands of pages of comments and lots of data and lots of information. And unfortunately, we have not been able to usually convince the agencies to do the right thing. We've probably improved some decisions slightly here and there, but we've ended up in court in most of the cases. But we have met that high bar, which again, overcoming the deference that courts want to give to these agencies, and showed them that no, these decisions just weren't based on solid facts. They didn't address all the issues that they were supposed to address. One of the things that I like to point out is that when the process starts, or when something might happen with an agency, when, for example, early on when MVP was first conceived, before any official applications were filed with the state of Virginia or with any of the federal agencies, we started looking at those processes then. And we started making arguments even before the official process started. One of the things I like to remind people is this is not a process that belongs to DEQ or the Forest Service. It's our process. Just like it's our environment, it's not theirs to do with what they will. This is our process. It belongs to us. And we get to have a say not only in how it comes out, what the final decision is, but how it runs. One thing probably a lot of people don't know, is that early in the process with the state of Virginia on Mountain Valley Pipeline, they did not intend to have a process for what they called upland work. They only intended to issue their permit for the in-stream work. And it was because we developed arguments before the official process even began that we kind of force them into that extra process. And so again, I guess I'm encouraging you to think expansively about, how the process should work. It should serve us, and it should be looking at the issues broadly instead of just kind of falling into a pattern that the agency wants to set. Another thing that we have done when it comes to permitting is to say, you're about to receive this application. For example, again, on MVP, they were going to issue or submit an application to both DEQ and the Corps. And we said, that application will not be complete unless you include this, 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 and this. And in some cases, DEQ came back and they did require more information than they would have originally. So again, I guess I like to color outside the lines. I like to insist that the process serve us. And I think you should just think expansively when you're doing that. Now, one of the great things that that happened because of the pipelines is that we then moved into what is now a rulemaking process in one area. What we showed, again, while Virginia and many of the other folks who've been involved, we showed that water pollution problems were being caused because of all the sediments and all the turbidity that was coming off the land. We got the attention of some of the decision makers, including members of the Water Control Board, and they were concerned that the system, the permits that DEQ was issuing, or that they were being referred to issue, weren't solving those problems. So the Water Board came back and said, hey, it appears that this permitting process, this permitting approach is not working. DEQ go and develop new water quality regulations for how to limit turbidity and solids. And so that's where we kind of, again, you search for ways where we make a difference. And sometimes it's frustrating believing you don't, but we did in that case. And now that hadn't been done yet. The DEQ has not followed all the way through, but that was where we were able to take what we were showing in the permitting process and push into a regulatory process. And then the last thing I'll say is that, again, what we've showed through these processes has led to legislation in the General Assembly. So we showed that there were gaps where things just weren't getting handled correctly in the regulatory process, and convince legislators to then come back and try to fill some of those gaps. So we kind of went to the lower end of the scale and said, this is not working. Let's go back up here and try to fix it up here. So much more I can say, but I'll stop there. Do you want to fill in anything else on that, Jackie, that you think I've missed?
No, thanks, Dave. I think you've covered it very well. Thank you so much for sharing that, those stories and those examples, and really providing details for how these acts can be useful for environmental advocacy. So we've got about a little over 15 minutes left, and so we wanted to have time for some questions. And please use the Q&A as you have been doing. So I'm going to go through and answer a couple I saw when I was skimming, just real quick. So first, yes, this is being recorded. And we will send out a link to the recording in an email, a follow-up email tomorrow. Also, in the chat, I've put the link to our last webinar, or one of our last webinars, which was on public comments. And we'll also include the link to that in the follow-up email too. And then Haley, you were looking at questions. Was there anything in particular? How do you think we should approach? Just Dave, you had a chance to look at them?
I've kind of skimmed a little bit.
Well, I guess since we were just talking about MVP, the top question was FERC required to follow the APA in processing citizen comments regarding the Mountain Valley Pipeline extension?
Well, the simple answer is yes, they're required to follow it. The hard question is, did they? um, the I think that I've explained to some folks that FERC, as Jackie explained, it's kind of a weird animal because they call it a quasi judicial organization. So while they have these people who work for them, these professionals who are part of the agency, they also act like judges. And so when they make decisions, it can be a little bit of a black box as to how they made the decision, because they come out with a formal opinion, but as far as how they're talking to each other, as judges, you don't necessarily get to see all that. But the important part is that they do come out with a formal decision, and that's what you get to, respond to. And that's where you can make a point as to, well, these comments just didn't get addressed. Then it's up to them to explain, why they didn't address it in their formal approach. I hope that makes sense.
Yeah, and I would just add that, as Dave was mentioning when he was talking about the type of evidence that agencies have to have in their decision making, they have to have a reasonable factual basis for their decision. Otherwise, the court will find their decision arbitrary and capricious, but reasonable is up to interpretation.
Yeah. Well, I'm just going to scroll down. Somebody says they find deference most frustrating, and you're right. And that's why, again, you have to understand what kind of evidence, what kind of arguments can work. And it's just a fact of the administrative process and of the way the law works at this point, that the agencies get that kind of latitude. So I don't know how to answer that, other than that we're just as frustrated sometimes as you are. But we have learned how to take the flaws and at least win sometimes. So that's good. Do you want to point out some good ones there, Haley?
Yeah, I thought a good question was, how are the people on the control board selected? This could have tremendous implications in terms of the rapid slide to the right, which we have experienced over the last 5 years.
That's a good question. The water board, the air board, waste board folks are all chosen by the governor. They're not all chosen at one time. They're on staggered terms. So maybe 2 terms will expire this year, 2 more next year, and so on. So in general, you will have some from different administrations, but there's no question that you can have a different slant possibly to the board depending on who nominates them. There are rules as far as conflicts of interest and things like that have to be abided. They're not real strict. Essentially what they come down to is you can't be associated with a party that is getting permits directly from that agency. Other than that, there's the governors have pretty much free reign as to who they choose. And, I'll just say that sometimes we can have some input on that. Folks have nominated members of these boards through time, and sometimes we can influence it.
I just wanted to add, this isn't about control boards, but it's also about administrative entities that help advise and make decisions. But there are also in Virginia regulatory advisory panels and technical advisory committees, and those are actually opportunities where citizens can serve, as well as members of the agency to advise the agency on particular matters. Didn't know, Dave, if you wanted to add a little bit more to that. And those those advisory committees are and panels are also subject to the VAPA.
And in fact, while Virginia is currently serving on 2 of those advisory panels, one for a regulation and one for a permit. And you know, it's a role that's enshrined in the APA. Once you become a member of one of those advisory panels, you're part of an official government body. And so all the rules apply there. And we've been encouraging folks, that's just another way that you can be involved to follow those processes, or even to volunteer to be on one of those advisory panels. So we think that's an important things for people to look out for.
How would people find out about those opportunities?
Well, that town hall that you mentioned is one way. We have tried very hard to let people know when those come up, when there's a process that we think we're going to be involved in. We have both encouraged folks whom we know have an interest to volunteer for those advisory panels, and we've pushed the state to reach out to different groups and different folks who may not have been represented previously. Pick us another good one there, Haley.
Yeah, so along those lines, at the federal level, we have APA, and in Virginia, we have VAPA. But what about at the local level? Is there a similar toolkit to hold local policymakers accountable? For instance, a county that writes its own water protection ordinance. Can the VAPA be used creatively in these situations?
The state law governs what localities can do. There's something in Virginia and a lot of states called Dillon's rule. And what it says is that localities only have powers and authorities that are delegated to it by the state. And so the state gives localities the power to adopt ordinances and rules, but they all have to flow from whatever the state said they can do, and they all have to fall within those guidelines. As far as the procedures, you can correct me on this, Jackie, but I don't think the APA itself governs those local government procedures. So you would just have to fall back and say, are they following the laws that the General Assembly said they had to follow?
That was going to be my answer, that that it doesn't necessarily apply at the local level, but they're still constrained. Localities in Virginia are constrained by the Dillon's rule.
And one thing that always applies is constitutional due process. So that's, you know, you go all the way back to the top of that stack of authorities. And that is supposed to ensure at least some kind of fair process when your interests are involved. Okay, what else you got? I can see that we're probably not going to get through all these because there's a lot of good ones. What we usually do is we save this and try to kind of weed through them a little bit. And I encourage you to follow up if there's things we don't get to.
Okay, what if the agency creates a rule without going through the notice and comment procedure? How do we hold them accountable?
The simple answer is you got to take them to court. And that's probably the easiest one to win, so it's really reckless for an agency not to follow the procedures. Again, that's not something where they get all that deference. When it's something within their scientific expertise or whatever, that's one thing. But it's not hard to judge necessarily whether you actually made a public, announcement, a public notice or not, or whether you allowed the right number of days for people to comment. And amazingly, a lot of times they skip some of those steps. Let me just make one more point about that again. And I know, again, we always come back and say, well, take them to court. but sometimes the court of public opinion can have a real role here. And when you call out an agency or an entity that just didn't follow the rules at all, and sometimes just the pure shame of making it public, of bringing in legislators, of having people say, hey, what the heck, can force them to go try again. So I never totally skip over that step.
Yeah, I'll just add that that's an important part of the helping keep accountable, is making a big deal about it publicly, because it is a big deal when there's something as blatant as not allowing a notice and comment period when they are required to. That is something that should be brought to attention.
And again, you know, I harp on this all the time. This is your process. And it's your process because you have interest that you have a right to protect, whether it's property interest, whether it's your interest in, you know, how your waters are managed or your air. So bringing your values, your interest into it is helping to tell the story.
Haley, why don't you pick one more? I want to be respectful of everyone's time, and we also have to announce the winner of the giveaway.
Okay. So one person said, I filed a FOIA request with FERC for records pertaining to the Mountain Valley Pipeline involving non-public records regarding landslides from January 1st, 2015 to December 31st, 2017. FERC advised no records were found. I appealed. The appeal was denied, but I'm certain that there are many records and FERC is illegally withholding them. FERC's actions prevented me from using those records to comment on the Mountain Valley Pipeline extension request. Do I have any options other than suing them?
The simple answer is probably not. I'm sorry to say. You know, I don't know of any other remedy. That's unfortunately, sorry to say. Okay. You want to stop there, or
Yeah, well,
any more?
I think we can do one more.
Yeah. Maybe.
That was, yeah, I was like, that was a pretty quick answer.
Yeah.
Like,
Unfortunately.
yeah.
Is it possible that a judge could order a stay on a project if found guilty of violating the APA?
Yes, that's an easy one too. You know, again, if the process is not followed, then people's rights have been, you know, harmed. And that's the standard for whether you can stop a decision or not. You know, is there real harm if you go forward without obeying those rules?
Yeah, provided you could satisfy the requirements for a stay or an injunction,
Right.
then that's definitely a possible remedy.
Okay.
All right. So thanks for all these great questions. We will look through them, and if there's any lingering ones we haven't addressed, we'll make sure to answer them in our follow-up email. So for everyone who attended this evening, you're put in for a drawing for a 1-month membership for 2 with gear to Rise Up Climbing in Lynchburg, Virginia. It's a $250 value. And so I put everybody's names into a random name wheel generator. And the person whose name was selected was Elena. So Elena, you have won the giveaway for tonight's webinar. If you can send your email address to send your email address in a message to me, Jackie, then I'll make sure that we follow up with you with that information.
Congratulations.
Yeah,
That's
congratulations. And thanks everyone for coming. Again, be on the lookout for a follow-up email with the recording, links to our past webinars, any answers to questions we haven't addressed. And thanks for joining us this evening. This is not the most exciting stuff, but it can be very useful and very effective in advocating for your environment and your community. So thanks for joining us and learning about this tonight. And Dave, yeah.
One last thing, I'm sorry.
Of course. No, don't apologize.
we don't intend to throw you into these things and leave you by yourself. One of the things we love to do is when we're involved in one of these processes is to give you guides and help you be involved. So we're not just saying, go out there and do it. Especially with things with DEQ and with the pipeline, we're always prepared to try to give you guides and help you follow these procedures. So we just like to give you some of the broad picture so that we know how to approach it later. So thanks everybody for being here. And I guess we'll sign off.